Hello and welcome to this first panel of our conference on the state of the Constitution, organised by the Constitution Unit at University College London in partnership with the Bingham Centre for the Rule of Law, the Oxford Constitutional Studies Forum and the UK in a Changing Europe. We have 6 fantastic sessions for you over the next 2 days. I'm Meg Russell, Director of the Constitution Unit, and I'll be chairing this first panel on constitutional standards. I imagine the topicality of this subject is obvious to everyone here. While normally a somewhat obscure subject, constitutional standards and regulation have been frequently in the news in recent years. We've had the Owen Paterson affair and Partygate, leading to the Prime Minister himself being under investigation by the House of Commons Privileges Committee over claims that he misled Parliament. He's lost not 1, but 2 ethics advisors through resignation, with Lord Wright last week suggesting that he'd been placed in, quote, an impossible and odious position. The Committee on Standards in Public Life has suggested a major strengthening of regulators, upon which the government has yet to act. In the meantime, we've seen controversies about public appointments, and as will be discussed tomorrow, over the government's attitudes to Parliament and the rule of law. Put in a broader context, these developments have led some people to suggest that the UK is experiencing a kind of democratic backsliding, whereby essential constitutional norms and standards are gradually eroded. Such concerns about the state of democracy currently exist in many countries around the world. We're joined by a fantastic panel to discuss these issues. Sir Jeremy Wright QC is Conservative MP for Kenilworth and Southam and a former Attorney General. He's been a member of the Committee on Standards in Public Life since 2019. Professor Liz David-Barrett is Director of the Centre for the Study of Corruption at the University of Sussex. She's a former journalist and has particular expertise on Eastern Europe. Sir Peter Riddell is a former journalist, former director of the Institute for Government, and until recently was Commissioner for Public Appointments. He's now an honorary professor at UCL. And Professor Petra Schleiter is joint head of the Department of Politics and International Relations at the University of Oxford and one of our partners on the conference. She's an external fellow at the Constitution Unit and has written widely as a comparative political scientist on constitutional topics. Each of our panelists are going to provide some opening remarks in that order for roughly 5 minutes each. After that, we'll move to some discussion between the panel for maybe 15 or 20 minutes and then open it out to questions from the audience. So please be ready with these. You can submit questions at any time. If you've got a question, please write it in the Q&A function of Zoom as opposed to the chat. James Cleaver, our Q&A facilitator, will select from among the questions that you submit and read some of them out. By default, James will also read out the name of the questioner, but if you'd prefer to remain anonymous, you can indicate this when submitting your question. This whole event, including the Q&A, is being recorded and we'll post it online on our website and YouTube channel afterwards, and it will become a Constitution Unit podcast. You may want to bear that in mind when deciding whether to ask your question anonymously. So that's enough from me. We're going to pass to the panel, starting with Jeremy.
Thank you, Meg, and good afternoon, everybody. Thank you to you and to the Constitution Unit for inviting me and for organising this conference. I should apologise to start with that in common with, I think, about half this panel, I've managed to contract COVID this morning. So if you'll forgive some coughing, I'll say a few words about the Ministerial Code, which is something that I've experienced from several different perspectives. I've been subject to it as a minister, and now, as Meg said at the introduction, I'm a member of the Committee on Standards in Public Life, which is considering at some depth its role and significance in the political standards landscape. I should say I don't speak for the committee. As people will know, only the chair of the committee can do that, but I will refer extensively to what we have concluded in relation to the Ministerial Code and give you some of my own thoughts as well. It is, of course, very topical, as Meg has said. And there's an awful lot to think about in terms of the way in which the Ministerial Code is structured and how it might change. It's worth remembering, and I'm sure many people tuning into this will know this, that the origins of the Ministerial Code is in a document called Questions of Procedure for Ministers, which dates back to the Major era. And for what it is worth, the Committee on Standards in Public Life thinks that what we should try and do is separate out the content in the document that we have about procedure from the content in the document we have about standards. And it's important to give the standards part of this document due prominence when we come to consider all the other things that we'll consider in the course of this afternoon's session. But let me just pick up on the significance of this code. So it is the Prime Minister's way of setting out his or her expectations of his or her ministers. And it's important that ministers understand what the Prime Minister expects of them. The code is the way to do that. So that's where its authority comes from. But its credibility surely comes not just from what the Prime Minister asks of ministers, but also from independent oversight of the way in which the code operates. And that brings us to the role of the independent advisor on ministerial interests, which is actually a recommendation of the committee on which I sit dating back to 2003. But we should probably ask ourselves when considering this particular position, it may be called the independent advisor on ministerial interests, but how independent in fact is it? And it seems to me the answer to that is probably not independent enough. And so let me talk through some suggestions as to how it might become more independent and more authoritative. And that's, of course, very relevant because as the Prime Minister goes around about finding a new independent advisor, just as when an independent advisor was required after Alex Allen's resignation, the CSPL put forward some suggestions to the Prime Minister as to what he might want to do. I think we can repeat and reinforce those suggestions now. So what are they? Well, I think first of all, it's worth thinking about the appointment process for the independent advisor. And that appointment process is not clear. And I think it would be sensible if we brought some greater rigor and clarity and transparency to the appointment process for the independent advisor. And Peter may want to say something about this from his expertise, but it seems to me we should do something that is analogous to other standards regulator appointments. And at the moment, clearly that does not happen. Secondly, it seems to me what we need is some clarity and probably a revision of what the independent advisor does and what the Prime Minister does in this arrangement. And I don't think that at the moment we are in a satisfactory position. So it seems to me, and it seems to the committee too, that we ought to have a situation where the independent advisor is able to initiate their own investigations. It seems to me that proper independence requires that. And that is not, I think, currently the case. And I say I think, and if you'll forgive me becoming a lawyer for a moment, I'm not sure I've understood precisely what the new version of the Ministerial Code says on this. And let me explain what I mean. I'll read you what the Ministerial Code, the new version of it, produced in May this year, says about this. What it says is at paragraph 1.4 of the code, subparagraph B, it says this. It says, where the independent advisor believes that an alleged breach of the code warrants further investigation and that matter has not already been referred to him, he may initiate an investigation. So far, so good. But it then says, before doing so, the independent advisor will consult the Prime Minister, who will normally give his consent. However, where there are public interest reasons for doing so, the Prime Minister may raise concerns about a proposed investigation such that the independent advisor does not proceed. Now, I think you can read that one of two ways. You can either read it to mean that if the Prime Minister raises concerns, that's that, automatically the investigation cannot proceed. Or you can read it to mean that if the Prime Minister raises concerns and the independent advisor is persuaded that those concerns are sufficiently valid that the investigation should not proceed, then the independent advisor could decide independently not to proceed with an investigation. Now, I think it's pretty clear from the mood music that surrounds the new version of this code that it is the former, not the latter. But as a matter of interpretation of the document, it seems to me there is room for some doubt. But let's assume for a moment that the way in which the code is structured in its new iteration is to say that the independent advisor may not initiate their own investigations. That seems to me to be an unsatisfactory position and should change. Secondly, it seems to me that the independent advisors should determine breaches of the code. Important that the Prime Minister retains the right to determine sanctions, but on the question of whether the code has been breached or not, authored by the Prime Minister in the first place, of course, it seems to me that's a proper role for the independent advisor. And the reason that I think the Prime Minister needs to retain decisions on sanctions is that there is an important constitutional principle here about who decides who ministers are going to be. Prime Ministers need to decide who their ministers are to be. Unelected independent advisors should not do that. And if we ended up in a situation where the choice of sanction, including, of course, a requirement for resignation, were the responsibility of the independent advisor, that would no longer be so. So both my view and the committee's view is that it's important for the Prime Minister to retain control of sanctions, and indeed, we think he should have more sanctions available to him than he currently or previously did. And that means it has to be more than just resignation. It could be other things too, because not every breach of the Ministerial Code is equally serious. So it makes sense that there should be a range of sanctions available. Now, if you do that, and by the way, you might think coincidentally, the only recommendation that we've made in this space that the Prime Minister has accepted is that there should be a range of sanctions available in the consequence of a breach of the Ministerial Code. But if you do have that range of sanctions, meaning that every breach of the Ministerial Code resulting from every investigation into a breach of the Ministerial Code does not have to result in resignation, then there is really no excuse for a Prime Minister resisting the idea that an independent advisor should be able to initiate their own investigations and should be able to determine whether breaches have occurred, it seems to me. So I think what we've tried to do is produce a package deal. The Prime Minister has, of course, selected some parts of that package that he likes, not other parts that he doesn't. I don't think that's a satisfactory position either. But I do think that there is good reason why, and this is my last point, why we have to do what we are proposing. We have to, in the view of the public, strengthen and bolster the processes that support standards in ministerial life. And that's because there is a significant erosion, as Meg was saying at the outset, in the public's confidence that ministerial standards are being maintained. Now, whether that's fair or unfair, perhaps doesn't matter. It's really important that the public do have confidence in what ministers are doing, and that they feel that ministers deserve the authority that they have. And if we ever needed any persuasion that that was true, surely we've seen the evidence for it in the last 2 years. That if government, as it clearly sometimes does, has to ask us to do some pretty unpalatable things, then it is absolutely vital that we as a population recognize that ministers do so with the right motivations, and that they act with the highest standards. And if we don't believe that, then not just ministerial standards are at risk, but the effectiveness of government policy is at risk. And that becomes very important when the effectiveness of government policy is designed to achieve our health and well-being, as it has been throughout the COVID pandemic period. So I think there's reasons why CSPL produced a report saying standards matter. Standards do matter. And they matter not just in the context of interesting academic fora such as this, but they matter in real life in the ways in which ministers operate, exercising the authority they need to exercise in order to deliver policy in practical terms. So perhaps, Meg, I'll stop there and look forward to the conversation a little later.
Wonderful. Thank you, Jeremy. There's some great detail there and also some really important kind of broad general points. I suspect there's a lot of agreement on this panel on some of those points. Let me turn to Liz now.
Great, thanks very much, Meg. What I'd like to do is to put the developments in the UK under the Johnson government in a kind of international context, and particularly by assessing them in the framework of a concept called state capture. So this is a concept that was coined to describe early years of transition in Russia. And what we saw there was that a few business people were able to gain excessive influence over the laws that were formed and the way that state assets were distributed. And that had big implications for the distribution of economic and political power, which we still see the implications of today. Essentially, a narrow group of oligarchs were able to gain a great deal of economic and political power, which has then skewed the way the country has developed. So that was a term that was developed 20 years ago. But what we've seen in the last decade or so is the term cropping up again in a number of different places around the world. And this seems to be used now to talk about a slightly different phenomenon where political leaders who are often democratically elected abuse their influence over the state to consolidate their power and avoid accountability. And I've argued that they do this in 3 spheres. So they're gaining control over the formation of laws and policy, the implementation of those laws and policy, and then they're also seeking to systematically weaken the checks on their power, which would constrain their ability to influence those 2 spheres. So the clearest example that we've got of this in the neighbourhood, as it were, is Hungary under Viktor Orban since 2010. So he has systematically used his power to capture the state and consolidate his hold on power. He won a 3rd term recently in elections which the OSCE characterised as being undermined by the absence of a level playing field. Now, it's no accident that the playing field is not level. That's how Orban has crafted it over the last 12 years in office. And I'll just explain how he's done that in terms of those 3 spheres. So he was elected with a 2/3 majority, and that gave him the right to change the constitution. But he did that in a number of really fundamental ways, very quickly, that strengthened his own power and weakened the checks and balances that are supposed to hold the executive to account. He systematically weakened the judiciary, so he restricted the jurisdiction of the Constitutional Court, appointed one of his cronies as chief prosecutor, changed the way that judges were appointed. He also silenced the media, restructuring the media regulator, appointing another crony to head the regulator. He channeled all the state advertising contracts to friendly outlets, and there's virtually no free media in Hungary today. He also changed the rules for getting elected by redrawing electoral boundaries, and he granted the vote to huge diaspora communities outside of Hungary's borders. So, do we see this pattern in the Johnson government's conduct? Let's have a look at that first sphere, influence over the formation of laws and policy. The British executive, of course, has quite significant influence over the legislature in a normal scenario, just through having a large parliamentary majority. The payroll vote and the party whip and discipline help, in any case, I think, in the UK to ensure that Parliament is a fairly weak check on the executive. But it has also become more passive in recent years, and it's also been systematically undermined. So the government has explicitly sought to reduce parliamentary opportunities for scrutiny of laws by excessive use of skeleton bills and delegated legislation. These provide the government with huge freedom to act at a later stage when essentially it's beyond parliamentary scrutiny. And the government increasingly uses bills which are fleshed out in guidance or advice that comes later, which also means that they're very difficult to challenge through judicial review. So that's the first sphere, the formation of laws and policy. In the second sphere, implementation, there have been a number of efforts by the government to install political allies into key public appointments, and I'm sure that Peter Riddell will tell us more about that. There's been abuse of the COVID emergency to set up the VIP lane for COVID contracts, which allowed ministers to recommend friends. And the National Audit Office found that those in that channel were 10 times more likely to win contracts. And we've seen also quite a number of examples of lobbying by insiders, most blatantly with former Prime Minister David Cameron using his insider status to lobby on behalf of Greensill. In that, we also found out that a senior civil servant had been serving as an advisor to Greensill for 3 months while still working as the government's chief procurement officer. So that was the implementation sphere. In the third sphere, then, we're looking at accountability institutions. And here, again, we've seen a number of acute attacks. The government has openly questioned the impartiality of judges. It's called for political oversight of judicial appointments. And it has planned a new mechanism that would allow it to correct court judgments that ministers believe are incorrect. There's been the ongoing attack on the BBC, the public service broadcaster, questioning its neutrality, weakening its funding base, and the decision around privatising Channel 4. And in addition, there have been all of the instances in which we've seen the regulatory bodies that are specifically around regulating the conduct of ministers undermined in various ways. And again, I think my fellow panelists are covering these, and we'll talk more about these, but we're looking here at the Advisory on Ministerial Interests, the Standards Committee, public appointments, etc. So I do think there's evidence that actually the UK is moving towards this kind of model, and there's evidence to suggest that state capture is a reasonable framework to use here. It's not the Orban scenario. There has been resistance and there's a lot of pushback from the institutions. But at the same time, there have also been a number of norms and conventions that have been violated. And that does lead to a kind of slippery slope where it's easier for people who come afterwards to again violate those norms and conventions without that being seen as so problematic. So I think our institutional protections against capture have become weaker. And I would plead that we don't assume that the UK is immune to what we've seen happening in Hungary just because it's an older and more mature democracy. There was also a time when Hungary was really seen as a beacon of democratization within Eastern Europe. It was known for the way that the end of communism had been negotiated and peaceful. The constitutional setup had been calmly negotiated by a cross-party group, no revolution or violence, and it had had several peaceful changes of power by the time Orban came to power in 2010. It also opened up its economy to investment in a way that seemed that it was going to be very much entrenched in a kind of liberal market model. So my plea then is that we don't assume that the UK is just immune and safe, and that we take these significant degradations in a serious manner.
Thank you very much, Liz. Fascinating and chilling. And I would love to ask you lots of things about that, but I won't do it now. Maybe we'll have time to come back to some of this in questions. I will pass on to Peter for his 5 minutes.
Thank you, Meg, very much indeed. I mean, it's a nice diversity of experience and view we've got this afternoon on that, and I want to take forward ideas both Jeremy and Liz have said. Particularly, I thought it might be useful to, as a former regulator, to look at some of the actual practical tensions which come through, which illustrate some of the points which have been made. And the most striking one in my 5.5 years doing public appointments was the tension between being an advisor and what one was trying to do in that, and the rights and interests of ministers. It tends to be that ministers are suspected for everything they do. They've got their rights too, and they're important ones. And for example, the public appointment system was a sense of balance between myself trying to ensure that there were competitions fair and open to identify the strongest candidates. And I didn't play any part in that, but I oversaw the interview panels and so on and so forth on that. But the ultimate decision on who should be appointed was left with ministers, and I think that was absolutely right. I don't think it would have been any way right for someone like me or for the panels to reach the final decision, because we were not democratically accountable. I was accountable to select committees, and I made myself publicly accountable in social media and so on and so forth. But I think that was right. The ministers had that accountability. One of my criticisms was they weren't necessarily accountable enough, and I'll briefly come on to suggestions I recently made to the Public Administration Committee to strengthen that, I believe. But so it was a balance between the two. And I think sometimes there's because people disagree with what ministers decide, is to say, oh, they're necessarily rigging the system. Yes, sometimes they do, but not always. And I think you've got to recognise the rights of ministers as the elected and accountable people, provided they respect a system which identifies the options, in the case of what I was regulating, to ensure that the strongest candidates in terms of those most qualified for the role in various ways came forward, and there was a diverse pool as imaginable. And that was the tension throughout between, and same applies to other regulators. Where's the tension between the balance between advice? For example, we've seen it on the House of Lords Appointments Commission when the Commission recommended against a large, in fact, donor being appointed. They were then overruled by the Prime Minister. It was all public. And in a sense, the Prime Minister has to take the rap for that and answer to that. Now, you could argue, should it be strengthened? Should it be a veto power? But ultimately, the person who's accountable for it has to be a minister. Similarly, as Jeremy said, in terms of the interpretation of who should serve in a government, of what sanctions should apply, it clearly is the Prime Minister who should do that. And I agree with him entirely. The problem is that the regulator's role wasn't sufficiently independent and strong in terms of either judging whether the code had been broken and recommending in the sense that also the fact of having independent inquiries. So it's that balance, and in many respects you can argue that the balance operates against the regulator at present, but the ultimate say-so, I'm suspicious of removing it entirely from ministers. And indeed, if you look at the example of the Judicial Appointments Commission, there, what was agreed now nearly 15 years ago in the structure there does give ministers, but they just have a simple veto. Even though we rightly prize, and I regard the Judicial Appointments Commission, there are problems there. I think of like appointing like and so on. But in general, that the Justice Secretary has a straight veto power. And that could be spread more widely, but it does ensure that there is a ministerial accountability at the end of the day there. And I don't think one can always do away with that. I don't think that there is necessarily panels of the good and the great should decide who gets what jobs. I just wanted to make that point, because the danger sometimes moving away from it too much. Now, clearly there are problems, and a lot of the regulators, we've seen that with the independent advisor. We've seen, Liz mentioned Greensill. I thought the interesting thing about Greensill was, of course, how totally ineffective everything was. None of the ideas Greensill had were adopted. They were fiercely resisted by the civil service. And I think a lot of, both what David Cameron tried to do and this bizarre story of the double hatting of the senior procurement officer, which it was very unusual. What was interesting about it was unusualness. Not to say that it's not it was a problem which Nigel Boardman addressed and should be addressed more rigorously in future. But it didn't actually change things. That's one of the ironies of it, in fact. And this also is rather objective to what was going on. So what can be done? There's a limited amount which can be done by rules. I think there's some elements. I endorse the CSPL report. Its suggestion, for example, that my old job and various other jobs should be put on a statutory basis. Look now, the independent advisor on ministerial interests, we're now told that the Prime Minister is thinking about it. We don't know how long that's going to be. There was a very entertaining exchange in the Commons yesterday afternoon when Michael Ellis, the Minister for, I'm trying to think of a polite way of putting it, but anyway, the one who protects the Prime Minister's back, let's put it that way, in very elegant language, we used the phrase in due course, and there was a lot of dancing around whether due course, which of the solstices it refers to. But that would not be possible if it was statutory. There would actually have to be a timetable. And for example, I was extended as Public Appointments Commissioner because I didn't have a deputy, and I insisted on a time limit to it. I said I'd do it for an extra 5.5, 6 months, and it duly worked out then. But otherwise, you can just either abolish something or leave a vacancy. So statutory backing, but also, as Jeremy hinted, I just got 2 or 3 other points. One, it's not just the statutory, putting them on a statutory basis to make it more difficult to abolish and also to indicate what the powers are, but the way of appointment is very important. And I agree with Jeremy entirely. The method of appointment of the independent advisor, where it's basically going around and looking at the appropriate chaps, which is what happened last time, is what's all happened, is unsatisfactory, and it should be much more transparent. And I agree with that should apply. And in fact, for the other posts, my old post, Civil Service Commissioner, Committee on Standards of Public Life, it's an open competition system. I would introduce more of an independent element to it on the panels, and possibly, like the Judicial Appointments Commission, ensure that one name is put up for the chairs, which ministers or Prime Minister can then accept or not accept. And I think that might improve things there on that score. So I'd go a bit beyond what the Committee on Standards of Public Life recommends. Final point I want to make is that rules only take you so far. And one of my experiences as a Public Appointments Commissioner was that culture and attitudes of ministers mattered as much, if not more. When I took over in 2016, there was a lot of controversy over the Grimstone review of the role of the Commissioner. In practice, far more important than the changes following Grimstone was the differing Prime Ministers and differing ministers. I mean, there was a very large difference 3 years ago when the Prime Minister changed. Also, individual ministers, there were some rogue ministers whom I identified in my course of when I was Commissioner. So a lot of it's to do with that. And I think a lot of that comes back to an impatience with scrutiny. people wanted to kind of fix the system. They were reluctant sometimes to go through it. And one advantage the rules did, it made it more difficult because you could embarrass people. You could say, if you don't do that, I'm going to go public. And that was a very powerful weapon some of the time to threaten to go public with dissent, because that's not the natural thing in Whitehall. But in general, when you've got an administration which is increasingly disliking scrutiny from whether it's from the courts, from Parliament, a very good point is made about what's happening on skeleton and other bills on that. And more generally, a more distant and dismissive attitude to Parliament, it makes it very much more difficult. I mean, moving to a kind of populist presidentialism, where the only thing that matters is the verdict of the electorate. And that was very interesting. It surfaced in the Tory leadership election earlier this month. And also, if you look through some of the language in the notes accompanying the Ministerial Code, that shows up too, a view that actually it was the verdict of the electorate, and scrutiny in between was much less important. So those are the factors I would bring out. Yes, you need to strengthen the rules, but as much as anything else is the attitudes and culture of the executive and of Parliament being more activist too.
That's terrific. Thank you very much, Peter. And of course, as I mentioned before, we do have a session on Parliament tomorrow entitled Parliament, the Decline of Scrutiny ? And we also have, in response to one of the comments in the chat, a panel on the courts and the rule of law tomorrow. I'm seeing that there's a lot of stuff going into the chat, and I think most of it is genuinely chat and just comments, which is absolutely fine and healthy. And we're seeing that there are people here from as far afield as India. There are several hundred people in this room, which is all fantastic. But just let me remind you, if you do have a question for the panel, put it in the Q&A function, not in the chat. But last and by no means least, I would like to turn to Petra for her opening remarks.
Thank you so much, Meg. So as a comparative political scientist, my role on this panel is a little bit similar to Liz's, and it's to place the constitutional developments in the UK in international context. So the questions of constitutional standards, the erosion of parliamentary and judicial checks, the weakening of the Ministerial Code, the willingness to break law and international law that we're currently observing in the UK are not sui generis. So they arise against the background of wider concerns internationally about democratic backsliding that Meg gestured to when she introduced this panel. And this phenomenon increasingly affects not just newer and less wealthy democracies, but also some of the longest established and most influential democracies around the world, including, of course, the US. So what do we mean by democratic backsliding? There are many terms for this phenomenon, including abusive constitutionalism, democratic erosion, democratic decay. All of these terms capture the subtle and incremental weakening of democracy from within for partisan benefit. And it involves the step-by-step weakening of three constitutive features of democracy. The first is fair elections, the second is political rights, and the third is the rule of law. And the thing about democratic backsliding is that it is incremental in nature, and that allows incumbents to slowly expand their powers, making it difficult to detect and counter until it can be too late, as Liz mentioned now is in Hungary. So what are the first signs that erosion is occurring in a country? And one of those first signs is that leaders tend to do two things to prepare the ground for the expansion of their powers. The first is that they tend to promote political divisiveness and polarization, delegitimizing those who think differently, and those who disagree with them are often branded as enemies of the people that do not deserve to be heard and that deserve no respect. Recall, for instance, the Trump campaign's "lock her up" refrain in the 2016 presidential election directed at Hillary Clinton, or the UK government's attack on the courts following the Miller rulings. Second, rulers promote expansive interpretations of their powers and make clear that they're not prepared to abide by existing norms, including legal and constitutional norms that limit what they can do. And I think the Johnson government's approach to constitutional standards has promoted precisely that, namely expansive and at times illegal and unconstitutional interpretations of the executive's powers. Specifically, the government has infringed on each of the three constitutive features of democracy, raising concerns about the emergence of an abusive form of constitutionalism in the UK. So turning first to fair elections, what we see with the Elections Bill of 2022 is that it undercuts the independence of the Electoral Commission through the introduction of a strategy and policy statement that enables the government to guide the Commission's work. With respect to political rights, we've seen the curtailing of the right to protest and the criminalizing of protesters by the Police Crime Sentencing and Courts Act 2022, which enables police to restrict protest, including a single person protest, and including where noise may cause a significant impact on those in the vicinity or serious disruption to the running of an organization. With respect to the rule of law, we've seen the expansion of executive power, complemented by the erosion of the power of Parliament, the courts, and other accountability mechanisms that have now been multiply mentioned on this panel, alongside deliberate rule breaking. So executive power expansion we've seen in the Dissolution and Calling of Parliament Act 2022, which not only transfers the power to call early elections from Parliament to the executive, but also, and significantly, makes the executive's actions with respect to assembly dissolution non-justiciable. We've also seen the erosion of other accountability mechanisms, for instance, judicial review. The Judicial Review and Courts Act 2022 introduces prospective-only remedies, for instance, which may leave individuals unable to be compensated for unlawful state action. And we've seen the rewriting of the Ministerial Code that Jeremy has commented on. We've also seen the increasing use of high-profile and deliberate rule breaches. The unlawful prorogation of Parliament in 2019 to achieve a no-deal Brexit, the Nationality and Borders Act, which unilaterally reinterprets the Refugee Convention, and there are multiple other such acts in progress. So these measures, I would argue, alter the political framework. They promote executive overreach and collapse checks and balances. Individually, each of these changes may look innocuous, but taken together, these measures normalize an abusive form of constitutionalism and substantially weaken the resilience of democracy in the UK from within, for partisan benefit. The experience of other countries shows that once underway, democratic backsliding isn't inevitable. It can be stopped if executive overreach is confronted. But that requires determined action by MPs, particularly MPs of the governing party, by courts, by independent regulators, and ultimately, possibly even the people. Thank you.
Great, thank you very much, Petra. That was very clear and also quite chilling. Petra hasn't mentioned this, so I will mention it instead, that there's actually a really interesting set of podcasts organised by Petra and her colleagues at Oxford University on backsliding, and I'm putting a link in the chat. There's also a piece on the Constitution Unit blog on backsliding, if anybody would like a fairly short read on that. Let me just see whether that's going to go. Yeah, there you are. There's a couple of links in the chat for you. Just a reminder to put some of your questions in the Q&A, and I'll invite James shortly to pull out some of the most striking ones and read them out and put them to the panel. But let me start by putting a few questions to the panel. It's a huge amount here. Maybe I'll start with Liz and Petra on the sort of international scene and where we fit in. You've both put an emphasis on the sort of incremental nature of backsliding or state capture. Liz talked about the slippery slope. One of the other things I think, which is probably quite important, and I'll be interested in your comments on this, is that this isn't necessarily a deliberate strategy. That I get the impression, looking around the world, that this is something that leaders can fall into quite accidentally. Do you think there is a risk, especially with what several people on the panel have referred to, our sense of kind of exceptionalism in the UK, that we're this very long established democracy, that we're incredibly stable, we've always been very proud of that. Is there a risk of complacency? Is there a risk of sort of accidentally getting into this kind of loop, do you think? Maybe go to Liz, because Petra's just spoken, and I'll come to Petra.
Yeah, thanks, Meg. Yeah, I think it's a really interesting question around how deliberate it is. I think small acts are sort of deliberately designed to resist checks and accountability. Whether the whole system is deliberate, I think, is much harder to prove. So there is definitely a sense that this number of small acts then lead into a big picture where actually you're in quite a difficult situation that it's difficult to come back from. And so I think it is really important to keep track of all the small things that are happening there. And in terms of a risk of complacency, yeah, I see a lot of this, to be honest. And I think in particular, you do also hear quite a lot of falling back on, well, it's elections that count, and if people don't like it, they'll throw them out. But actually, electoral accountability in the UK is really weak, and it's weak partly because of the first past the post system, which just means we have so many saved seats. And it's also weak because of quite strong partisanship. So actually, even if people really don't like what's happening, they often feel that they don't have other alternative choices to go to. And so I think actually elections are not really functioning as a strong accountability mechanism in the UK. And that's one area where I feel in particular, we are a bit prone to saying that we can rely on that, and I really don't think we can.
Yeah, just to add to that, maybe, I think you're absolutely right that this isn't necessarily a deliberate strategy. I'm totally prepared to believe that the vast majority of MPs are trying to do their very best and don't see this at all as a deliberate strategy, but they try and deal with each and every piece of legislation the best way they can. But I do think that it's particularly for this reason that it's important to see the larger pattern, and that it is important to see how these various measures across various types of policy areas add up. I do think that once a country has been a stable democracy for as long a time as the UK has been, it's very easy to believe that it is exceptional and that democracy is invulnerable. And we see that in other places too. I think it's fair to say that, in Hungary or in Poland, many people were not prepared to believe that actually their democracies could very significantly backslide to the point where maybe they're not really democracies anymore. This is quite a common phenomenon in processes of backsliding, precisely because they are so incremental. And it's hard to join up the dots, and it's hard to believe that actually this might be happening in your country. And it's particularly hard to believe, I think, for those with a stake in the political system and with significant influence on politics, because it makes the choice harder to sort of think about, am I just working constructively within the system, or is there a point at which I need to say it's important to put a stop to some of this? I would say that the point, you can stumble into backsliding, and I think how parties and how governing parties in particular stumble into backsliding is when partisanship becomes more important than democracy. And that's, I think, where things begin to go wrong.
Thank you very much. Let me turn to the other two members of the panel. I think there might be a connection, a link up here. One of the ways in which we are, to an extent, exceptional, although this can also be overstated, is our political constitution rather than legal constitution. And I had a piece on the Constitution Unit blog a few weeks ago suggesting that gives MPs, and this relates to something that Petra's been saying, a really important constitutional duty, which goes above partisanship, to protect standards. And I would be interested to know whether Peter and Jeremy think that MPs realize the extent to which they have that duty and are prepared to exercise it. And maybe that's connected to another question about the CSPL report. Obviously, there's been some increasing pressure from inside Parliament to get that implemented. So we had the Opposition Day debate, which the government didn't oppose. David Anderson's got a bill in the House of Lords to get some of that stuff into statute. How can we make that happen? How can people in Parliament work to strengthen the system? I don't know who wants to go first. Peter is unmuted. Is that a sign?
My response is it's very patchy. It's really patchy. I was very struck yesterday watching the debate on the Opposition Day on the replacement of the independent advisor. That there was a number of Conservative MPs, all of whom were on the Public Administration Committee, who were quite passionate on standards issues and were effective and so on. One, it was a very ill-attended debate, and I don't think just because of strikes. But I'm struck, as on many issues in Parliament, it's fairly patchy. And the if I might describe it as a Nadine Dorries response, who knows, who cares, tends to be the inertia option for a lot of people. And so also another indicator is that the attendance, for example, at pre-appointment hearings, where MPs can have real influence, over selections and so on, and having been through it myself. And it's significant for a preferred candidate. Often the attendance is very poor and very weak. So it's my answer to that is it's very patchy on that score. Also, opposition parties veer between taking a damn them all position, an extreme position, and pursuing some of the subtleties of it. And they're not always as effective as they could be. Because they get to they're all scoundrels view, which of course unites the government party and so on. Could I just say one thing on the previous point? Is I think you've got to distinguish. I think there were some concerted things after the experience of 2019, not just Dominic Cummings, but other people. There were concerted things at two levels. One, we want to get our people in. Well, that often happens, but it's taken as a more extreme thing. And our people was as much ideological as allies. And second, the determination to change the rules of the game, as both Liz and Petra have said. And I think that is quite. I mean, I remember I've had discussions, say over the Supreme Court, over the way Parliament is run, and the quite deliberate attempts to change the rules of the game as a result of the 2017-19 experience. So I think it's different from in the past. It's not just we're going to get allies in position, which is a perfectly reasonable thing both major parties do. I think it's different this time.
That's really interesting. And Jeremy, maybe you could pick up some of that as well, that if this is a partisan issue, it's unlikely to work because it just unites the governing party. But without wanting to put you on the spot too much, the governing party doesn't look that united at the moment. So I suspect that there may be quite a few people on your benches who are very well aware and very concerned about these matters. So how do we move it on? Is there sort of enough of a sense of the importance of that constitutional protection role, do you think, among your colleagues?
I don't think there probably is enough of that. I don't think it's absent in its entirety. And I do think that, as Peter says, it's patchy on different issues and at different times. These issues have a different degree of prominence. But look, I mean, I'd say several things. I mean, first of all, I think there's a danger of crying wolf. Not every political debate is a standards question. And there's a risk that standards language is co-opted into what are political arguments. And that's a serious error, because what that does is it devalues the currency, so that when you have a real standards question where people really ought to sit up and take notice, then it's less effective because you've heard a breach of standards bandied around as an argument as part of every debate. And frankly, there are as many issues that are about political judgment as they are about constitutional standards. So important that we, I think, reserve our positions on constitutional standards matters for issues where it is genuinely a standards question. The second thing is that, and I don't think that we should buy into the idea that there was a golden age of British politics or of constitutional propriety. I don't think there probably ever was. But I do think that a couple of things have changed in the last 5 to 10 years in the ways in which members of Parliament in particular feel a commonality of interest in defending certain institutions and principles. And those two things are, I think, the coarsening of political debate, for which I largely blame social media, but not exclusively, where people have retreated to extreme positions rather than being prepared to concede that actually the other side of the argument might have a point once in a while, and that actually we probably agree more often than we're prepared to admit. The second thing that's happened, of course, is Brexit. And regardless of your position on Brexit, I don't think it's possible to deny that that has been massively divisive in the way in which British political thought has been constructed since. So this is a wedge issue which has changed the way in which we do politics fundamentally, it seems to me. So finding a way of bringing people back onto common ground where we accept that certain things are not about partisan interests, they're about defending constitutional propriety and the kind of institutions that, regardless of whether we're in government at the moment or not, we all have an interest in defending, has become increasingly hard because politics is more and more polarized. I'd also say, I mean, I think what Liz says and Petra says about state capture is really interesting. But of course, you have to recognize that there is a significant part of the political spectrum that thinks that's what's been going on for the last 40 or 50 years, that there's been the capture of the state institutions by a liberal elite that they are now trying to redress the balance on by saying, no, we're going to take back control, to use a phrase you may have heard before. We're going to redress that balance. So that's part of this polarization of the British political debate that does not help, I'm afraid, in establishing the kind of constitutional common ground that you're describing, Meg. I don't think it's impossible, and I think there are plenty of us who care passionately about it, but it is much harder to refract through a very noisy political debate, which I'm afraid too often tends to play in questions of standards into what are in fact questions of political disagreement. And we should reserve, I think, our views on standards for things that are genuinely standards matters.
Yes, it's a difficult line to tread, isn't it? Because even when things are genuine standards matters, the response can be your party politicizing this. So how you walk that line is very, very tricky, I think. I'm going to bring James well, I would invite James to turn his camera on and start preparing to give us some questions. I think I would be failing in my duty if I didn't just point the audience. I've just put another link in the chat towards our Democracy in the UK After Brexit project, which has asked lots of questions of the public about their attitudes on constitutional standards and found really, really strong support for integrity and honesty in politics. So there is a thirst for that out there, which our research shows. And what we need to do is get there before people become so turned off from all politicians, tarred with the same brush, as I think somebody said before, and think that the whole system is broken. Do read that research if you're interested. James, what have you got for us?
Thanks, Meg. We're going to begin with 3 questions. These 3 are on the standards regime. So Arabella Lang from the Public Law Project asks, the Ministerial Code currently requires ministers to comply with international law. See Gulf Centre for Human Rights versus Prime Minister. This has been under considerable strain recently. How does the panel think this should be addressed? Tom Wilson asks, does the panel think it problematic that backbench MPs and peers are subject to more stringent transparency requirements and to more rigorous/independent investigations than ministers are in respect of their ministerial duties? If anything, this seems to be the wrong way round. Does the panel have views on how this can be addressed and generally on the overlap/interaction between the ministerial codes and the parliamentary codes? And finally, an anonymous attendee asks, can the panelists comment on the extent of oversight of the devolved administrations in Scotland and Wales? For example, in Scotland, there have been worrying reports of civil service politicisation.
Great, thank you very much. Quite a range of questions there. And I don't know who wants to go first. We don't have to bring everybody in on every question here in order that we can fit in more questions. Jeremy's unmuted, so go ahead.
Well, I was going to say I'd perhaps start on the international law one. This was a live consideration when I was Attorney General, and I had to make several public statements to make it clear that ministers do indeed have to comply with obligations on government under international law. But I think it's probably worth being clear about what we mean by that. So international law does not find its way into UK law unless it's incorporated by specific action of UK law. So the international law that we're talking about is generally things that the UK has already agreed to do. It has itself accepted that it will incorporate those obligations into its domestic obligations. The fact that there are international agreements out there that the UK hasn't signed up to obviously has no bearing on a minister's actions. But where the minister is dealing with an obligation that the UK has voluntarily signed up to, then it seems to me pretty straightforward that that's part of their ministerial obligations. And we needed to make that very clear. I would welcome sufficient clarity being given on that now. And then just on the other question about whether there is greater scrutiny and more effective scrutiny on MPs than on ministers. Well, of course, ministers generally are also MPs. And there is something, I think, to be said for operating parallel regimes where you have to register your interests or your gifts in both places. There is a difference in the sense that ministers quite often get gifts that are effectively given to the department or given to the government rather than given to them as individuals. But the fundamental point is that I agree that at the moment, there is greater independence in the oversight of standards among members of parliament than there is in the oversight of standards among ministers. And that's a fundamental deficiency in the way in which the ministerial code and its independent oversight operates. And that's why I talked at the beginning about how we might remedy that. But I think that is a fundamental deficiency that needs to be put right. Absolutely, I do.
Thank you.
Meg,
Peter? Yeah.
Just on the final one, when I was Public Appointments Commissioner, I liaised quite closely with my opposite numbers in Belfast and Edinburgh, and I was I was also the regulator for the Welsh Government, which is a kind of curious anomaly left over by the consent of successive First Ministers and Welsh Government. So I had quite a lot of perspective on that. And some of the codes, for example, in Scotland on public appointments, looked tougher than the one I was operating under, and so on and so forth. But you had to look at the political circumstances. And there's been one party in control in Scotland now for 15 years. That was as powerful, and as pointed out in the question, there are issues of the everything is not rosy necessarily north of the border in relation to ministers and civil servants, because of the political situation. In Northern Ireland, I remember a discussion with my opposite number there, she now stepped down, who'd been a human rights lawyer, who asked me, Peter, how many times have you been judicially reviewed? And I looked at her blankly and I said, well, actually, I haven't been judicially reviewed at all. We work round the legal thing. She said, well, I'm constantly in court because of sectarianism. It was still an issue in public appointments in Northern Ireland between the two main participants in the power sharing government. So you've got to look at the political circumstances heavily in the different places. In Wales, there are different problems because of a very small nation and the kind of domination of sort of Cardiff as well. So you can look at the rules, but actually an awful lot depends on the particular political circumstance. And that's one of the advantages I had of looking at Wales, because one learned a lot from that. So I think we can learn a lot from the constituent parts of the UK, but not necessarily believe that the ostensible rules are a guide to what actually happens.
Liz, I suspect you've got some views on standards regimes.
Yeah, I just wanted to come in on the second question, actually, about the regulation of ministers versus MPs. And yeah, I do think it's the wrong way around at the moment, that the conduct of MPs is more tightly regulated and more independently regulated than that of ministers. And the reason is that I think the principle here should be that there's tougher regulation and accountability where there's more power. And actually, MPs don't really have much power, individual MPs. I mean, actually, part of what we've been talking about is that they don't have very much power. So there's clearly a lot more power in the hands of ministers. And for that reason, there should be stronger accountability over how they exercise it.
Thank you. Let's go back to James for another round of questions then.
So 2 questions in this round about how to bring about change. So Fen Willie Gale asks 2 questions rolled into one. Is there a recognisable point of no return where backsliding, state capture, etc. becomes substantially more difficult to reverse? If so, what would be the first priorities to achieve in reversing this long-term trend? Perhaps better education of citizens about democratic norms to combat populist impulses. And the second question is from an anonymous attendee who asks, how much would the strengthening of parliamentary scrutiny of secondary legislation act as a check and balance on the powers of ministers? What sort of scrutiny would you like to see of secondary legislation, often coming out of skeleton bills?
Okay, 2 excellent questions. I think we can fairly come to Petra on this round first. I'm sure you have a lot to say on the first question.
Yeah, so is there a recognizable point of no return? It's a difficult question. I mean, generally the consensus is that once we see very significant erosion across the 3 constitutive features of democracy, and that is the rule of law, it's free elections, and or fair elections, right? And it's the third element, which is political rights. Once you have real erosion across these 3 arenas, it is harder to arrest the process. And that's simply because executive overreach has been normalized to a point and checks and balances have been weakened to a point where it becomes difficult. Now, judging what is significant erosion in each of these arenas is really hard to tell until you see the legislative measures that are being implemented in action. And because there is, as Liz has said, there is the sort of formal legislation, then there is the implementation where we really see how it plays out in practice, right? And so it's difficult to tell ex ante the real point of no return. But I think once you see proper, sustained assault in each of the 3 arenas of or constitutive features of democracy, it's time to get worried.
And it feels to me like this connects to points that were made earlier on the panel about the challenges of cultural change as opposed to structural change, that democratic culture gets eroded too, doesn't it? It's not just about removing powers from judges or whatever. If the citizens begin to lose faith in democracy, you get mistrust, you get a sort of sense of hopelessness, you get increasing polarization. It's going to be very difficult to bring it back. And I feel those dangers, and Jeremy's referred to this a bit, I feel those dangers here. I think we see them in developed democracies all over the world. Liz, what would you add to that?
Yeah, actually, I think this comes back also to Peter's point around, it's not just rules that we need here. It's, can't remember quite how you put it, Peter, but there's a limited amount that can be done by rules, I think you said. And actually, this is, you can call it culture, but I think actually you can also say it's about individual integrity. It's about, are individuals willing to stand up when they see lines being crossed? And that is going to involve some individual cost for them. But it also has an empowering effect on other people, because it makes them more likely to stand up and resist as well. When you see that no one's standing up, then you feel like I'd be an idiot to stand up and resist this. And so there is this kind of, ratcheting effect or, collective aspect of this, that it's not just that an individual makes a stand, but by doing so, they also make it much more possible for other people to do so as well. So I think, more people standing up and calling out their peers in Parliament would be excellent, and being prepared to suffer potential costs of that. And also just to talk about the point of no return, I think it's really difficult to identify a point, but I think the overall thing that's important here is, once you start to change the rules of the game, that has an impact on how power is distributed in society. And once you've got a skewed distribution of power, then that narrow interest group has economic power, which they can then use to further consolidate political power. And so you do get this vicious cycle or circle building up. And that's why it's so important. And that's why this kind of high-level corruption, this changing the rules of the game, really undermines not just rule of law, but also how an economy develops over time. It's got a real significant emphasis and impact for inequality.
Can I just say one thing? That I'm also struck by, one shouldn't take a monolithic view of it. There are very different strands within government. I mean, I think a really important thing I found as a regulated 5.5 years, it wasn't them versus me or anything like it. It was a much more complicated picture. The power to, Liz uses a very good stand up in Parliament, not just stand up in Parliament. I found that the power of embarrassment and disclosure and transparency could discourage things. And I found when I took a stand on one or two things, there were a lot of people who said to me, we agree with you entirely or whatever. You had to be careful what you did, and you can't overdo it, otherwise you become ineffective. But it also, if you look, if one looks through on appointments, all right, you can point to some that some people would object to. Quite a few people just didn't get through. The system did work partly in being tough, and that applies in other areas. I mean, for example, there was a lot of attention a couple of years ago to the purging of a lot of permanent secretaries, and this is I might describe as the High Cummings era. And there were quite a lot of people purged then, forced to early retire or even sacked. It's died down a lot. So, and indeed, if you looked at some of the replacements, they were very much people, if you knew anything about the likely candidates, would have been likely candidates at any stage. So it's not entirely a black and white picture. It's on the whole, it's a more complicated one. But I agree with you. I mean, once some of the systems are changed, it becomes much more difficult. And that's why I agree with what Petra said earlier. That's what's so worrying about the recent Electoral Act, because that could have very profound long-term implications with parallels to what's happening in the US.
Jeremy.
Yeah, I agree with what Peter's just said. I think it's essential that you maintain the integrity of institutions like the Electoral Commission, who are designed to avoid this kind of party political capture. But I think perhaps it's worth saying something briefly about the second question that we've been asked, which is around secondary legislation and how it gets properly scrutinised. This is very difficult because, as probably people on this conference will recognise, there's an awful lot of it. And so it doesn't get a great deal of scrutiny simply because the volume means each piece gets limited scrutiny. I think, to be honest, the answer is what was adverted to earlier on in the session, which is simply to have less of it. If you are going to divert attention away from primary legislation and towards secondary legislation by saying we'll worry all about that later and fill in the gaps and the details when we get to secondary legislation, then you can expect that that secondary legislation will not get as much scrutiny as the primary legislation did. And that's clearly not right when you're dealing with issues of principle that ought to be scrutinised properly at primary stage. So I think it's a question of parliamentary resistance to the idea that very large amounts of serious questions have to be resolved at secondary legislation rather than at primary, where they're more appropriately determined.
And I think there's a general difficulty, I'm sure we'll turn to this at the session tomorrow, of primary legislation increasingly. It's not just a criticism of this government, previous governments, being used as sort of signalling device to communicate to the public that you're doing something without yet having thought through what it is that you want to do. And then the delegated legislation is where the detail gets added and it's not properly scrutinised. So that's a bit of a cultural problem as well, I think. James, I think we've probably got room for one more round. What have you got?
Yeah, and this round is 3 questions about the culture of standards and politics. So Jack Newman asks, are the problems identified by the panelists problems arising from the structure of institutions or from the wording of rules/laws, or from the behaviour of individuals, or from our political culture? The obvious answer is all of these things, but which are most important and which are possible to change? Ben Young asks, if Peter is right and rules only go so far in ensuring constitutional propriety, then the traditional alternative, as he seems to suggest, is to look to virtues in culture. Is the answer to encourage more virtuous politicians? And similarly, Mafamwe Lloyd also asks, what can we do to restore/increase a desire for integrity amongst politicians and leaders?
That's a very consistent set of questions and a very good place to end. One of them was pointed directly at you, Peter, so why don't you start this time?
Yeah, if only Aristotle or Plato are on the panel. They may well be. I mean, given the wisdom of my 3 fellow panelists, they probably are there. It's very difficult to envisage how you encourage virtue. The only thing I would say, which is a slightly different one, is not to discourage people from becoming elected politicians. That is a fundamental aspect of this. It's to encourage people who ensure they're not turned off by everything we've been talking about for the last hour and a quarter or so. On the multiple choice question, the beginning one. Which is it? I think culture is very, very important. How you change it, again, extremely difficult. I think we've seen, as Jeremy rightly said, 2 major factors coinciding: the growth of social media and Brexit, which have led to a very polarized political debate, and so on and so forth. It's very difficult to see how either will cease to have their very significant influence for quite some time over British politics. And I think certainly on social media, it'll take a very long time for a more balanced view to come through on that. So I do think it'll take time for culture to change, but there are cycles. In 3 or 4 years' time, we may be talking about very different personalities at the top of politics, and that may well change things. But there is no easy prediction.
One of the questions perhaps coming out of our public opinion research is whether there's an opportunity to be seized by somebody who wants to stand on an integrity platform, which could be an opposition party leader, or it could be a future Conservative leader. Jeremy, you have unmuted, so go ahead.
I have. Yeah, I mean, look, I think it's possible to see cycles in British politics anyway, where we have different kinds of leadership at different times. I'm choosing my words with extreme care here. And so it is possible to see that the cycle will turn. But look, I agree with Peter. I think that one of the most fundamental questions that we are not talking about in these debates is how difficult it is becoming for the kind of people you want in politics to go into politics. Because people will say, as they have in these questions, well, look, the answer is a change in culture. The answer is more virtuous politicians. The answer is people who won't need the rules to tell them that they should be behaving better. They will simply want to do so. And those people are out there. They're out there in large numbers, and they're not uninterested in politics. But what they're perceiving, not, I think, wrongly, is that politics is becoming a more and more hostile environment where you are subjected to more and more vicious abuse, particularly if you are female, particularly if you are from an ethnic minority, such that people are just not prepared to make the necessary sacrifices in order to enter political life. And unless we recognize that if we flood the political narrative with the kind of ideas that say all politicians are awful, all politicians are dishonest, all politicians are spineless, all politicians are only in it for themselves, which, by the way, in my experience, and I suspect in yours too, isn't true. The vast majority of politicians are none of those things, but they are facing incredibly difficult questions that are always harder than they look from the outside. But if we flood the narrative with those kinds of lines, then we can't be surprised when the kind of politicians we want in the business just don't want to come into it. And that's a vicious circle, because it means that the worse your politicians are, the worse your politics is. So I think we are going to have to think quite carefully about this as a society and decide what we want to say to potential politicians through the narratives that we are deploying to existing politicians. And I say that not solely because I'm at the wrong end of it now, but because I think if we do want virtuous politicians, and don't we all want that, we're going to have to encourage virtuous people to become politicians, not discourage them from doing so.
Liz and Petra, we're very much coming up against the end of our time, but I'd like to offer you the opportunity both to come in, and this is a big challenge. I don't know whether there's a way we can end on a note of optimism on what's been a rather depressing panel at times. Liz.
Yeah, I mean, I would have said pretty much the same thing, I think, as Peter and Jeremy, that I do understand it is really tough actually being an MP, and it's difficult to get people to go into politics for that reason. And the onslaught on social media is really unpleasant, and who would want to put themselves through that? I do sort of hope that we could maybe come up with some more sophisticated messages. And actually, I think your work at the Constitution Unit with the citizens' juries and that exercise of actually engaging people in talking about the issues has made me really optimistic that I think people are really actually willing to engage in a higher level of debate. They just need the chance to do it. So I think we should do more in that direction.
I think our research shows that there is sort of latent support out there for what might be a movement for decency and integrity in politics, even a movement for sort of calm debate in politics. But I think there's also a lot of hopelessness. I'm not sure people have the hope that it can be achieved. It's what they want, but the question is how we get it. Petra.
Can I throw in a practical suggestion, Meg? I know you're up against it, but this is one of my favourite hobby horses. Let's bring back the long political debate and questioning and interview. Because when we were all first interested in politics, you used to get John Humphreys interviewing politicians for 40 minutes. I've never seen that recently. And it does change the nature of the politicians you get, whether they are obliged to deal with a 40-minute long interview rather than a 4-minute long interview or even less. I think we should do that. That might help.
I think there's a lot of truth in that, but there's also quite a lot of nice stuff going on in the podcasts along those lines. But of course, people aren't always exposed to them. Petra.
Yeah, thank you. I mean, clearly, it's, it could be institutions, individuals, culture, and we've heard quite a lot about the hope that, we may get a new cycle of politics, and that may change, individuals, it may change culture. And I think I'd like to say, with respect to the culture, we do see the influence of social media, no doubt. We do see the influence of Brexit, no doubt. But there is a particular responsibility for our political leadership in shaping the discourse and in not coarsening it further. And I hope that, at some point that message gets through. Now, to the extent that institutions, individuals, and culture are all interlinked, I'd say that the institutional changes that we've seen over the last few years go in the wrong direction. They attract people into politics that are prepared to put partisanship over democratic norms, and that's not a good thing. So I think there's a double incentive to stand up to changes that roll back to democracy, because it helps us to attract better people into politics again.
Thank you. Maybe the movement starts here. We are over time, so it just falls to me to say thank you so much to the panel. Thank you to James for fielding the questions. Thank you enormously to all of you in the audience for coming along and also for asking such good questions. As I mentioned at the start, the recording of this session will be available soon on our podcast and our YouTube channel. We'll alert you in the audience when it becomes available, and I hope you might want to share it with your colleagues and friends. If you are listening live to this event, the next session begins in less than 15 minutes on the hour, focused on Northern Ireland, the protocol, and the future of power sharing, where there's also certain to be plenty to talk about. You can attend by just staying on this Zoom link, and the next panel will arrive on the hour. So we hope to see you there, and if not, at another of our events very soon. If you're not already signed up to receive news of the Constitution Unit's events and publications, you can do so on our website and also follow us on Twitter. But thank you very much, everybody, for now, and goodbye.